Okay, Ms. Kennedy, Mr. Thatcher, everyone's here. We're ready to proceed when you are.
Thank you. May it please the court. My name is Matthew Thatcher. I represent the appellant, David Murphy, who is the former husband in this appeal. We would like to reserve 5 minutes of our time for rebuttal. Your Honors, there are issues of equitable distribution, alimony, and child support raised in this appeal. I'm going to start first with the issue of the child support, which I think is the shortest of the issues. The final judgment attaches to it a child support guideline worksheet where the trial court has an erroneous calculation of the number of overnights for the time sharing. Under 61.30, the court is required as part of substantial time sharing to calculate the number of overnights. The number of overnights used is 78, which corresponds to 26 weekends of Friday through Monday morning, which was the regular time sharing. But the final parenting plan and the final judgment gives the former husband winter vacation time, summer vacation time, all other times that include weekday time that are in addition to weekend that would not be otherwise traded off as part of the holiday time with the wife. So the number is clearly in error. The argument in the wife's responsive brief was that it was not raised in the former husband's motion for rehearing, but it was raised in the motion for rehearing. We identified that in our reply brief. It was just that when Judge Hinson did his initial order, he only identified certain of the multiple issues raised in the rehearing that he would actually consider on rehearing. So it was raised, but he did not allow further argument on it. But I believe, looking at the plain language of the parenting plan, the number of overnights in the child support is incorrect. It is a statutory error by the trial court and requires that the child support be reversed and recalculated based on the correct number of overnights in the parenting.
Let me make sure I've got this straight. So this issue was not actually argued at the motion for rehearing. It was raised in your motion, but was not one of the ones that Judge Hinson agreed to hear. Is that right?
Yes, sir. Yes, Judge.
Okay. Because I thought it was kind of extraordinary, actually, that you guys had a very long, detailed final judgment, and then Judge Hinson agreed to hear a motion for rehearing, and then prepared another long, detailed, comprehensive final judgment on top of that. So for a case that looks like it's been going on for quite some time, it seemed like everybody was getting along reasonably well, and the judge was doing everything he possibly could to try to get this right.
Yes, sir. The trial counsel filed a fairly large motion for rehearing that had a voluminous number of issues. The trial court identified only certain ones that he would consider on rehearing. And
Right.
Those were the ones that were actually argued at the rehearing hearing, if you will.
Right.
But the child support was one that was not identified by the trial court as one that he would consider further argument upon. So that's why it carried forward in the appeal.
Opposing counsel, I'll be wanting to hear from you on whether that's waived or not. I know you put that in your brief, so please be prepared to address that.
Then, Your Honor, there's the issue of equitable distribution, and both the appellant and the appellee have raised really two sides of the same coin on this issue. And it's 610757, the issue of identification and valuation of marital assets. It's undisputed that there was a 1-year delay between the filing of the case and the service of the petition upon the former wife. But under that statute, the identification of marital assets is the later of, or the earlier of, the date of a marital settlement of an agreement, the date set forth in a premarital agreement, or the date of filing. And in this case, it's the date of filing. The trial court found in his final judgment it was the date of filing for identification of marital assets and liabilities, which is a hard line, bright line bar, which this court reaffirmed last year in Trichler, that basically everything up to that point in time is marital, everything after that time is non-marital.
Now I want to spend a little bit of time on this. This is your thrift savings plan issue.
As well as the retention bonus raised by the former wife.
So the petition was filed August the 29th, 2014.
Yes, sir.
So that was the date that this TSP was designated as being marital up until that point, correct?
Yes, sir.
And then some additional contributions were made between 2014 and 2017. And if I understand the argument correctly, you're saying that these were made out of non-marital assets. And so whatever was contributed after the filing should have been excised from the ultimate equitable distribution chart.
Exactly.
Is that right?
Exactly, Ron. This is an employer-employee retirement plan, kind of like a 401k, but through the military.
So
He
the
was
closest,
contributing
the
payroll
closest,
to it.
the closest valuation that you all put in the record to the filing was at the end of 2014, the valuation was $33,278.19. Sound right to you?
Sounds correct, Your Honor.
Okay. And so then you're claiming, and I was trying to retrace the amounts that's actually involved here. For 2014, you're claiming that $1,912.18 was non-marital that was contributed.
Yes, sir.
My question would be, how do we know that that money was contributed before filing, or I'm sorry, after the filing?
We know because of the record evidence, because that came from the former husband's payroll and his year-end tax statements that showed the contributions, as well as from the statements from the retirement plan that were received into evidence. So since the divorce was filed in 2014, the 2015 statement from the TSP showing contributions in 2015, those would be chronologically post-filing contributions. So all of his payroll contributions that went in after the date of filing, with the exception of maybe a 30-day overlap around the date of filing, if you're being paid in arrears from your employment, would be non-marital income earned after the date of filing. It's analogous to how we look at it before a marriage with a pension. All the contributions that were made before marriage are non-marital, everything after marriage are marital. This is just the inverse.
So to try to nail down the amount that you're being, the gross number I came up with, and I can tell you how I got there if we get that detailed, was $11,225.48. Is that the number you're claiming?
We had identified this by the specific years that sounds about correct.
The way I got there was $1,912 for 2014, $1,211 for 2015, $5,532 for 2016. All of this is in the record.
Yeah.
And then $2,569.50 for 2017, for a total of $11,225.48. Is that what you're claiming?
That would be the contribution. The other component.
Yes, that's his non-marital contribution.
Correct, Your Honor.
Okay.
And where the trial court kind of went off was he does have discretion to value, but his discretion to value is only the portion that existed on the date of filing.
So the trial judge valued this TSP as of the date of the final hearing without removing the non-marital portion of the assets. That's the claim, correct?
That's what happened, unfortunately.
Okay, a couple more questions and then we can move on to something else. According to the final judgment, the TSP valuation was $52,510. That's how you can get to that by plugging back in the penalty amount and the tax amount, because the penalty was $5,251. So, and if that's 10% of the total, then the total is $52,510. My question, and according to the final judgment, it says that was valued as of the date of the final hearing, but there's about 5 dates for the final hearing. So I was wondering where that $52,510 number comes from, if you know.
I believe it came from one of the statements. There was one of the statements around the time of the final hearing that gave a specific value. And I think that's what the trial court was relying upon. Because with a lot of those retirement statements and bank statements, you go with the date that the statement provides you. They don't always give you the exact date of the trial. Okay,
so if I've got a handle on this, then you're claiming that $11,225 should have been backed out of it. Even if the judge decided he wanted to give an unequal equitable distribution, he should not have valued the entire fund as marital, correct?
Correct, because it's legal error to award a non-marital asset to the other spouse, which is effectively what he did by including those post-filing contributions.
Okay, all right, I think I've got that. You can go back to whatever you want to tell us.
And Your Honor, the other side of that same point is what we're already talking about, which is the retention bonus that the former wife raised in her brief. That was and the trial court in this case correctly excluded it from the consideration.
Right, the trial judge considered that to be all non-marital, if I remember correctly.
Yeah, as I said, it's the other side of the same coin. It was applied for after the date of filing, and its ability to be retained is contingent upon him continuing to remain employed in the U.S. Navy after the divorce. All post-filing labor, post-filing effort, it would be by definition a non-marital asset, so it can't be included in ED. It doesn't matter that the wife and the former husband may have discussed during the marriage him one day applying for this or him getting bonuses in the past. This particular bonus is purely a post-filing non-marital thing. Much like in the Caruso case we cited in the brief, where the parties discussed starting a business venture, it was created the day after the divorce was filed, and it was a non-marital asset because the date of its creation was what counted in relation to 610757, not the prior discussions and genesis of it. It was the actual date. And in this case, the actual date is more than a year after filing and after the former wife had been served and after she filed her answer. The remaining issue, Your Honor, is with regards to the issue of alimony. And in this case, we've got a statutory issue under 61.08 where it appears, I think from the facts of this case, that the trial court has violated the prohibition against exceeding the length of the marriage with the durational alimony award. 6108.1 says that there's only a certain limited number of types of alimony, and it's enumerated. It's bridge the gap, rehabilitative, durational, and permanent, or a combination thereof. There's no other forms of alimony identified in the statute. 61.087 says that the length of a marriage, the alimony for durational purposes cannot exceed the length of a marriage. And we know from the statute and case law, specifically 61.084, that the length of a marriage is from the date of marriage to the date of filing. Trial court correctly found that in this case, the length of the marriage using those poll stars is 13 years, 6 months. This is a case that pended for about 3 years. But then at the end of the 3-year pendency, the court awarded 13 years and 6 months of alimony on top of 3 years of support already being paid. The result of this is if you've got a 17-year duration that's being paid in alimony on a 13-year marriage.
Although the actual alimony award itself that was labeled alimony does not exceed the marriage, but you're arguing that the support that was given in the interim, even though it was not alimony, should be counted against.
Absolutely, because there's nothing in.
Is there any case law that says that?
No, and I think this is a unique thing in the statute because you've got a statute that contemplates alimony pende lite, but it doesn't say what kind of alimony it is. 6108.1 says that there's only these forms of alimony: bridge the gap, rehabilitative, durational, and permanent. Doesn't identify or contemplate specifically an award of temporary alimony. And you can't look to a combination of alimony here because the judge didn't award permanent, denied rehabilitative. Bridge the gap is specifically capped at 2 years, and this proceeding pended for 3. So really, the only thing that makes any sense is that you've got to call this alimony, or in the case, some form of durational alimony, and you've got to count the term that he was paying towards that term. And the wife kept filing motions towards the end of the case for further temporary relief, and the court denied it because he was providing temporary relief. He paid the rent, he paid her car insurance or health insurance, and first $3,000 a month, then $2,000 a month in support, all the way throughout the duration of the case. Under the facts of this case, he's effectively going to be paying her 17 years of support on a 13-year marriage. I don't think that's contemplated under the statute, and I don't think the statute contemplates that the time frame from the date of filing to the date of the judgment is a legal limbo where it's just some form of vague alimony not contemplated by the statute. You can also look at 6108.8, which says that alimony for permanent purposes is following a dissolution of marriage, whereas durational alimony is specifically just following a marriage, and everything after the date of filing under that statute is following a marriage. I think you have to consider that time frame as part of that duration when considering the alimony duration and whether it's going to exceed the length of the marriage. Most cases.
Don't you think if the legislature had intended that, they could have written that in the statute?
I think they kind of did by saying all time following the marriage and then defining the length of the marriage as ending on the date of filing. I think the way that this is structured, when you limit alimony to just those enumerated types of alimony, that they were contemplating that every minute after the date of filing would be under the auspices of durational alimony, because they didn't create temporary alimony in this.
Well, if that were the case, and for some reason there was a spouse that wasn't getting very much support, wouldn't that create a perverse incentive for a spouse that would be paying alimony to stretch out the proceedings as long as possible because they're on the clock and not actually paying an alimony amount?
Well, the court can structure temporary alimony. The court can, not temporary alimony, the court can do bridge the gap alimony. The court can do rehabilitative alimony. It can make any combination of these different forms of alimony. The court could have said the first 2 years of this is temporary alimony and the duration will start at the end of the 2 years, which I think would fit within the statute. But here, even if the court was to do that, this proceeding pended for 3 years. So you've got a full 12-month gap where there's this limbo that's not, where alimony is being paid or support is being paid that exceeds, that it's not recognized under the statute one way or
But
the
it was
other.
just support. It was support to continue paying for the 2 daughters, to pay for the rent, to pay for the other expenses. Why should she be punished during that time where they were continuing to give a year of it? She didn't even know, arguably, that this was going on. And I agree he did the right thing by coming up and giving a substantial amount of money. But if he's doing it to just get credit towards his 13 and a half years, no more, then why is that not a perverse incentive for people to draw out the proceedings?
Because she's not being punished because he supported her, and the trial court had discretion to go back to the date of filing if the court found that he was not adequately supporting her and increase that amount. The court didn't do it because he was adequately supporting her and the family. The amount of end support that the court awarded between alimony and child support was equivalent with what he'd been paying her all the way through the case. I mean, she's effectively getting a double dip where she gets this 3 years of support plus the 13 years on the back end. She wasn't denied on the front end because she received the support on the front end. He's effectively being penalized by the proceeding being drawn out, not really the other way around. Because the court—
Mr. Thatcher, excuse me, but you're into your rebuttal time. Use your time as you wish. I just want to give you the heads up.
You're muted, Mr. Thatcher. You're
Yeah,
okay.
Okay.
You muted on purpose. Got it.
Okay, thank you. Ms. Kennedy?
Thank you, Your Honor. Just to clarify initially, because this case does involve the appeal, as the court's aware, and a cross appeal, it appears as though Mr. Thatcher's responded to the issues in the cross appeal at the same time as the initial appeal. So initially I was going to request 3 minutes for rebuttal with regard to the cross appeal. If the court feels that's appropriate, given the manner in which we are proceeding, I would ask for that to respond to the issues raised on the cross appeal.
Yeah, to deal with the cross appeal after Mr. Thatcher responds, I'll give you a couple of minutes.
Thank you. I appreciate
All right.
that, Your Honor. First, to address the issues raised on the appeal by the former husband, the issues presented involve quintessential trial court exercising its discretion in these proceedings. And to address first, before I get into sort of the two main issues that I see, with regard to, I know Judge Black, you had some questions about the calculation of the child support of the parenting plan.
Right.
And yes, I will concede that if you look at the chart or the form that is attached to the final judgment, the 78 days appears mathematically to be 26 times 3, which would be the every other weekend. The parenting plan, however, is not as straightforward as former husband gets the children these 5 days, these 6 days. It is a process by which no parent will have the child for 3 consecutive weekends. So it falls as every other weekend. But if one of those vacations falls within that, then the judge specifically said no parent will have them for 3 consecutive weekends. So then necessarily it's going to remove either the preceding or the subsequent 3 days because, for example, the former husband wouldn't be able to have the kids for the 3 weekends in a row. That being said, it does appear that certainly just with days during the week that he would have them, that certainly is something that does not appear to be correctly calculated. Whether it results in the change of 1 or 2 days, or, as suggested, the 10 to 15 days is unclear because as I said, it's going to really depend on, he gets the kids for Father's Day, but she gets the kids for Mother's Day. So that's sort of a wash. It's not going to really increase the percentage of time either way. But that certainly that does appear to be perhaps an error in how that calculation was done.
Do you agree that this was an issue that was raised that just was not heard on the rehearing?
That is correct, and I will correct that statement. It was not raised at the hearing. However, in going back and reviewing the initial motion for reconsideration or motion for rehearing, it was an issue that was addressed by the former husband. That he did not provide an explanation as to what the amount really should be or how to calculate the amount, but there was sort of a paragraph made that, in fact, the 78 days appears to reflect an inadequate amount of time.
So you're conceding that we need to recalculate the number of days on that issue?
I don't know. I am not aware. I'm sure if, based on the record, if this court can do that, but certainly
It needs to be done.
Yes. Yeah.
Okay.
With regard to sort of the discretionary issues in this matter on the initial appeal, the thrift savings plan, the trial court made extensive findings and comments regarding what the court referred to as maneuvering by the former husband. And I appreciate Judge Black's comments that, everybody seemed to be proceeding kind of amicably. And I will say that certainly comparatively to other cases, that might have been the case, but there were
I sat in family law for a couple of years. I know how it can get, and I think Judge Stargill did as well. So
absolutely.
For better or for worse, you're dealing with a couple of war-scarred veterans.
Correct. Absolutely. But I will say, I think it's important though to look to, particularly with regard to this issue, Section 61.0757 provides that the date for determining the value of a marital asset is whatever date the trial judge determines is just and equitable under the circumstances. The trial court in its order went through and explained that the former husband, you quote, used this account as a way to create his own savings while depleting marital assets and to inflate his expenses during the pendency of this case.
But that's a valuation that it's referring to, not to what actually constitutes a marital asset. When you're talking about an account where contributions are being made, as opposed to is a piece of property a marital asset, and then you're valuing it. So we're talking about an account where at a certain point, funds stopped being marital per the statute.
So the fund itself, the judge did classify as a marital asset, but the court exercised its discretion under the statute in saying that it was going to value that account at the time of the final hearing. The court said as a way to, the court said this is one asset the court can value at the time of the final hearing to rectify the husband's maneuvering. So it was an effort by the trial court to exercise his discretion under the statute to do what the court felt was just and fair, given the manner in which assets were put into that account. The court
using that same analysis, do you think that a trial court could say, well, I think it would be just and equitable to go back 3 years before the date of the marriage and value and use those funds because of the way somebody behaved?
And Your Honor, those are cases that actually were cited by the appellant in their brief to say that this was improper, and they were premarital contributions. And the courts have said that the premarital contributions could not be considered. I think this is different because you have, the court is given discretion on the valuation. In this particular case, the court made specific
but
findings.
Valuation versus the bright line rule of what constitutes a marital asset are two different things.
They are.
In fact, in this case, your client is is actually conceding that there's non-marital funds put into that account. That's the whole rub here, is that his assets were being depleted because he was contributing to this TSP, and that's the reason he couldn't pay some of these other things. So it's not, I think what Judge Stargell's saying is what seems to me to be the correct analysis, which is valuation is one thing, but the court, I don't see how it can just take a non-marital asset, call it marital, divide it and give it out. There's a non-marital component to this that needs to be backed out before it can be valued and distributed, it seems to me. And those are the numbers I was running through with Mr. Thatcher.
Correct. And again, even the issue though, Your Honor, with those numbers is that the numbers for example, for 2014, the petition was filed in August of 2014. So then contributions that were made certainly prior to that would not have been non-marital. She was not served with
Mr. Thatcher says that the record supports, and I'll have to go back and look. I did have the actual record that shows the account balance is at page 2238. But that's one of my questions I had for him is I don't know whether the 1912 was given before the filing or after the filing. I couldn't tell from looking, but I'll try to figure that out. Or maybe if we send it back, that'll be something for you guys to argue. But a lot of these numbers that are being claimed actually clearly came after the filing.
They did. And a lot happened after the filing because as the court noted, there was a year in which the former husband was still living with Miss Murphy,
right.
Was attempting to reconcile, or she at least believed they were attempting to reconcile. So there were a lot of things that the court discussed and made findings in the final judgment that went to, again, as the court stated, this is one thing that I can do to try to rectify the
setting aside whether the court can do that or not, or make an unequal distribution, that's not the issue. What I don't see how the court can take a non-marital asset, call it marital, when it clearly is not.
And I think what the court did, Your Honor, is the court again looked to the asset is the account, and instead of piecing apart, so the asset is the account right. Is marital, so now we have to value it. So how do we value it?
Well, you value it by figuring out what was the passive appreciation versus how much of non-marital assets was put in there, and you do the best you can.
Right, and based on the statute, provides that you can value an asset as the court, in the court's discretion, to accomplish equity or to achieve equity, and the court's statements are consistent with that to achieve equity, valuing at the time of the final hearing was a way to achieve equity given the, as the court said, maneuvering or things that had happened in the case with regard to that account. And I understand the court's position as far as looking at each submission into or contribution into the fund separately, but the asset and the value, the asset itself is the account. And we believe that it was an exercise of the court's discretion in valuing that account at the time of the hearing, again, using the discretion that's provided for within the statute. But the other issue presented with regard to the alimony, and again, we can consider them together, but to take sort of issue 2 on the initial appeal, the argument was that the trial court, again, and the court has observed, I mean, it was a very detailed, lengthy final judgment. There were several findings that were laid out. The court went through several factors supporting alimony in this case. There is it's within the court's discretion under the statute to award alimony for the length of the marriage. That's what the court did. There is no legal support within the statute or case law to suggest that the length of the marriage is defined as the length of the marriage less the time period between the filing of the petition and the final hearing if the husband is making payments. I mean, that's just not contemplated by the statute. If the legislature had wanted there to be some sort of credit or calculation done based on that, then that could have been included in the statute, and it is not. Another issue that I don't think was addressed in oral argument, but is in the brief, is the former husband has argued that the court erred in finding that Miss Murphy was able to work 25 hours a week instead of imputing full-time income. And again, this was discretionary. We think the record fully supports and the order fully supports the trial court's exercise of discretion in determining that, based among other things on the age of the children, their activities, that she, the court found, was the primary, if not at times the sole parent that was transporting the children to and from their soccer activities and their the 4-H club activities, that FFA, that imputing 17 to 21 hours, per week was appropriate. And the court even noted that given the fact that the former husband would have the children more on the weekends, that would allow her more time to work, which is why that number was greater than what she was currently working at the time. So we believe that there's no evidence that would support imputing full-time income. There was no testimony or evidence regarding who would take care of the children if that were to occur, who would transport them, who would take them to or from school. And certainly it was within the court's discretion to find that the 17 to 21 hours was appropriate. Additionally, the amount of durational alimony, there's an argument made in the brief that, in fact, that amount was based on, or improperly based on, the parties' post filing standard of living. And in fact, the court specifically found on page 42 of the order that Ms. Murphy's need was in line with the marital standard of living. On page 49 of the order, the court specifically went through and stated that the husband actually didn't have the ability to meet her entire need, and said that both parties had to downsize because it wasn't feasible to continue the same marital standard of living post dissolution. So there's no abuse of discretion in the amount of alimony that was set or the duration for which it was set. And the record evidence and the findings in the final judgment clearly support that the court did not improperly rely on post-marital standard of living, but rather repeatedly referred to, in fact, the marital standard of living, and actually advised that they would have to downsize in order to make up for that difference. On the cross appeal, the issue of retroactive alimony, retroactive alimony was not denied. Retroactive alimony was not even considered by the court. And the court specifically made findings discussing the fact that Ms. Murphy incurred approximately $25,000 in cash shortfalls. The court referred to extraordinary unexpected expenses that she had encountered. The court detailed that the former husband had initially been paying $3,000 a month, then unilaterally lowered that amount, and then stopped paying for the children's half of the children's extracurricular activities. The court discussed that she was required to expend a considerable amount of money on credit card debt during litigation. The court said because the husband reduced the support he was providing. The court also then noted that he refused to pay the children's extracurricular activities. And he noted that Ms. Murphy, quote, needed to run up credit card debt during the pendency of this proceeding to make ends meet. Now, those facts were not made in support or not in support of retroactive alimony. However, there were these facts that were found, these findings by the court. And then within the final judgment, the court states that there is no retroactive alimony awarded. The wife did not request retroactive alimony. And the brief, we've gone through the many instances in which retroactive alimony was in fact requested by Ms. Murphy. The argument
whether it was requested or just the court decided not to give it, it's to the court's discretion, correct?
It's within the court. Yes, it's within the court's discretion not to allow it, but it's not within the court's discretion. It's not an exercise of discretion to say, I'm not awarding this because it was never asked for. That is just shutting the door.
So
and
if
not
the
even
court was
considering
in,
it.
so if the court was in error because of the tipsy coachman or whatever you want to attribute it to, the judge, on one hand, you're arguing it's his discretion to go 13 and a half years and give the full durational, but not for him to come back on the other side and give a retroactive.
Respectfully, Your Honor, I disagree. It is not. In fact, it is not an exercise of discretion to say something has not been raised and therefore not address it. For all we know, based on the findings in the final judgment, they support retroactive alimony. So the court saying, I'm not awarding it because it was never asked for, does not in any way indicate that the court exercises discretion in evaluating whether retroactive alimony was appropriate. In fact, the court shut that door and didn't even consider that, which is why it is not an exercise of discretion. It's in fact the opposite. The court chose not to exercise its discretion in deciding whether it was appropriate or not because it improperly believed that the issue had not been raised. So, for example, if this court didn't consider an issue that I briefed because the court just missed it, the page was excluded from my brief, and you said, no, well, I'm not considering, your third point because it wasn't included. And then I come back later and say, no, look, see, the pages, 28 to 42 were my last issue that you just didn't see. You saying I'm not going to consider it doesn't mean you exercise your discretion in actually thoughtfully considering and evaluating whether there's a legal basis for that claim. And here the court, made the point of saying, hey, here's all these things that happened that, you incurred all of this debt and you did what you had to do and things that would provide a basis for retroactive alimony. And in fact, the court wasn't even doing it for that purpose. So if the court actually was considering the issue, there may have been additional findings that were made, but we don't know because the court said, I'm not considering this because it wasn't raised. And that because it wasn't raised is error. It clearly was raised. So the court, perhaps, Your Honor, if the court had said, I'm not considering this because it wasn't raised, but even if it had been raised, I find based on XYZ, retroactive alimony isn't appropriate, then I think that could be a tipsy coachman scenario, perhaps. But that is not what we have here. We actually have the opposite, where the court seems to be delineating factors that would support retroactive alimony and then saying, but it wasn't, requested, so I'm not going to consider it. And so I don't think that this is a tipsy coachman situation. And I don't think this is a situation where it could be said the court exercises discretion. In the example of the 13 and a half years of alimony, that is something that is demonstrative in the final judgment that the court considered, and the court exercises discretion in deciding the length of the alimony and made that decision.
Ms. Kennedy?
Yes.
Excuse me for interrupting, but if you want to save a couple of minutes to have the last word on the cross appeal, you're going to have to wrap it up.
Thank you, Honor. I appreciate that. And the final issue, which we've briefed, is the military bonus. Really, the heart of the issue there is that should be classified as a marital asset, and we've briefed it. The issue really is that it was not something. It's something that accrued. The right to the military bonus accrued during the marriage. It is something that the application was submitted into evidence.
Isn't it based on future years of service, though?
The bonus is obtained, and obviously he has to still be employed to obtain the bonus. Yes. However, the ability to apply for that bonus was based on prior military service, which again, there's extensive findings by the court of Ms. Murphy's efforts in supporting her husband and the family and allowing him the opportunities to be able to have that 15 years of military service, which enabled him to get that bonus. And it's more than just they discussed it beforehand. I mean, this was something that they actively worked toward establishing him to be able to, in fact, have the ability to apply for this and receive this bonus. So therefore, it should be classified as marital. Thank you.
Thank you, Ms. Kennedy. Mr. Thatcher, 5 minutes.
Thank you. Thank you, Your Honor. Starting with that last issue with the TSP, Judge Stargell hit it right on the point. He has to continue to be employed under the terms of the contract with the Navy to receive the bonus. Whether he had the right to apply for it based upon something that happened in the marriage, the fact is the right to receive it's contingent upon post-filing, post-marriage effort. It's a non-marital asset. It's a non-marital right. It's non-marital income.
There's no way you can characterize that as a deferred compensation.
No, it's not deferred compensation, because in deferred comp, you've earned it and they just pay you later. Here, you're earning it later. So I agree with Your Honor, you can't call it deferred comp. Looking at the issue of the retroactive alimony claim, what I think needs to bear in mind is that during the pendency of this trial, which wasn't a compacted trial, it was spaced out over a period of time, the former wife filed several motions for temporary relief, where the trial court effectively was dealing with the issue of the temporary support and repeatedly denied her request for additional relief. And while the court may have fallen into the tipsy coachman paradigm of not properly saying that he analyzed that she didn't have a further need for temporary support, he clearly contemplated during the pendency of the case and the pendency of the trial whether or not she was being adequately provided during the pendency of the case, and repeatedly entered order saying that she's being adequately provided. The former husband should continue to keep providing as he's been providing. And then you look at the end award, it's consistent with what he was providing. I don't think that there's a basis for any reversal with regards to the denial of denial of retroactive alimony. On the issue of the TSP, one of the cases I think that is important to look at, one we cited, which was the Weininger case. One of the things when you look at the trial court's findings, the trial court put a lot of weight upon the fact that there was a 1-year delay between the filing and the service of the case, and that 1-year delay justified the unequal distribution or whatever equities the court thought were appropriate. Part of that being valuing the TSP and the non-marital portion as all marital. In Weininger, the parties' divorce lasted 9 years, and it was a Delta airline pension that the husband contributed to over the 9-year pendency of the divorce. And in that case, the third DCA said it was correct to value it on the date of filing because all of the contributions after the date of filing were non-marital. The TSP is the same thing in this particular situation. And going to the issue of the alimony, it's clear the trial court did value and quantify her need based upon post-filing and post-separation expenses. The trial court says as much. The amount of her need is based upon her 2017 financial affidavit. All the trial court did is back out, and he says it on page 42 of the final judgment. The trial court excluded the section on the financial affidavit that was identified as children's expenses and took out $100 of her credit cards that the trial court says were marital, that were going to be paid off as part of the equitable distribution. That was it. And when you look at her financial affidavit, without getting into the minutia of whether or not the food budget was all her or the kids, or whether it was consistent with lifestyle, there's $696 of non-marital post-filing credit card debt service that the trial court expressly excluded in equitable distribution because it was non-marital, that the trial court's including on her need for alimony. The trial court clearly is including post-separation expenses in determining her need. That was an error and an abuse of discretion by the trial court in determining her need. At the minimum, her alimony need goes down by $696. And we would just stand on all of the arguments that we set forth in our brief and ask the court to reverse as it related to the award of the non-marital portion of the TSP, reverse as it relates to the alimony award, both as to the awarding of a 17-year term on a 13-year marriage, awarding her more than the marital lifestyle that exceeded even the amount of the former husband's income during the marriage, and reverse as to the erroneous calculation of the child support, and affirm as its exclusion of the post-filing retention bonus, as well as the denial of retroactive alimony. Thank you, Your Honor.
Thank you, Mr. Thatcher. Ms. Kennedy, a couple of minutes till you have the last word on the cross appeal.
Just very briefly, Your Honor, and I appreciate that. With regard to, again, the retroactive alimony, it was not a denial of retroactive alimony. It was actually a refusal to even consider entitlement to retroactive alimony. And that is the error. It's not tipsy coachman because it's not the court was correct for the wrong reason. The court, we don't really know what the court's reason was, right? The court never even made, again, had the court said, I'm not going to award it because it wasn't asked for, but even if it was asked for, here's why she's not entitled to it, that might be a tipsy coachman situation. Here we have contrary to the arguments that the court found she was adequately supported, a review of the final judgment reveals comments and findings that are not consistent with that. On the record, page 1369 is a portion of the final judgment where, again, the court goes through and makes specific detailed findings that, in fact, because the former husband had unilaterally lowered his support and had not paid the children's expenses, that she had incurred all of this debt. The record does not, in my view, the trial court is not touting the former husband as this beacon that was so wonderful and magnanimous and provided all of this support to Miss Murphy. And in fact, there are specific findings to the contrary, that in fact she was left in a position where she incurred substantial debt because her needs were not being met and the needs of the children were not being met, including over $3,000 in charges from the bank, where she had to exceed her, there were bounce check fees and things like that the bank had imposed. And these were all things that were discussed by the trial court as having occurred. And again, these are things that actually—
Didn't the trial court also address the fact that she did not go back to work and she was capable of going back to work?
He did. And again, that was a portion of why the court imputed with the alimony, the durational alimony, the fact that she was underemployed and that she could work the 17 to 21 hours. But in spite of that, and even having made that finding, the court still continued to repeatedly make findings that, in fact, because of the husband's lack of compensating during that time period, that she had, again, incurred substantial credit card debt. And so, again, the court failing to even consider an issue that was properly raised is certainly a legal error and something that should be reversed for the court to properly consider whether retroactive alimony was appropriate in this case. Thank you.
Thank you, Ms. Kennedy. Thank you both. Our next case this morning is Siesta Key Association versus City of Sarasota.